All right, let's talk about what the consequences are if you improperly categorize your 1099 contractor. If you improperly categorize your 1099 contractor, if you in fact should have been having an employee, you will get an assessment from the EDD and the FTB, frankly, but you will get an assessment. You will get an assessment for the unpaid employer taxes you should have been paying on that putative employee. All right? You will get charged interest on the unpaid employer taxes. I believe that's 10%. Don't quote me, but I believe that's 10% per annum from the date on which it would have been due. You will get a penalty on the unpaid employer taxes. I believe, don't quote me, that's 15% on the employer tax side. You will get a bill for the unpaid withholding. You know, the stuff that you should have been taking out of your employee's salary and paying over to the government, that kind of stuff that they get very cranky about. You will get a bill for the unpaid withholding. You will get a bill for the interest on the unpaid withholding. You will get a 30% assessment on the unpaid withholding. And then when you think you're done with all of that, do you really think the federal government's going to miss out on all the fun? Yeah, they're coming after you too. Because as soon as this is finalized, electronic notice goes to the federal government. Yep. And then you get this assessment. It's wonderful. Here, let me explain, you could also have a lot of other problems, not just money problems, although it all comes down to money. Because if you end up with that prior situation, just think how much it's going to cost you in legal fees and accountant's fees to fix that. I'll take questions right after. Let me just quickly finish. Is that okay? All right. So anyway, so the potential consequences of an improper classification also include other things, like a labor code enforcement action. To give you an example, Cal OSHA comes in. Someone gets hurt. You're saying it's your independent contractor. They're looking at you going, no. Now you got real problems. If somebody goes in and files a labor code action, your 1099 contractor, then you have another problem. All right? Workers' compensation. I want you to think about this. You have a 1099 contractor. That 1099 contractor slips and falls at your premises. Doesn't say a whole lot to you. Say, oh, you okay? You know, go to the doctor. You're all right? Everything good? Good. And then all of a sudden you get a notice that 1099 contractor filed a workers' compensation claim. Not only are you going to have to face the issues of whether they are actually an employee or a 1099 contractor, just wait until they determine that it's an employee and you haven't taken out workers' compensation insurance on them. All right? These are not fun things. I don't wish this on anybody. In 33 years of practice, I have represented many clients through this. All right. I want to point something out here. There are always, and I don't think in this group, but there's always some smart aleck in a group that I give this speech to that is thinking to himself or herself, you know what? I'm going to take my chances. All right? I'm going to take my chances. They come after me and put a bill on me that's too big for me to pay. I'll just tank the company. I'll open another company, probably do the same business, probably even use the same contractors. Well, Sparky, there's a thing called responsible party liability. And responsible party is actually responsible parties, could be. That means anybody responsible for paying that withholding amount, which, by the way, is trust funds. That's why they get cranky. You're holding your employees' funds for the benefit of the state, and you've stolen them, according to the way of thinking. All right? They get very cranky over that. So they will come after you with responsible party liability. Guaranteed it's the owner of a small company. Larger companies, it will also include CFOs and COOs. All right? So you will be responsible personally, as a personal obligation. You will be responsible for that withholding, the interest on the withholding, and the 30% penalty. And guess what again, Sparky? Non-dischargeable in bankruptcy. Okay? The last thing that you're going to face if you go down this road is the AG or the DA under this new statute has been given authority to enforce this agreement, and the DA has been given authority to enforce this agreement through its city attorneys. So if you're one of these people that go in and redo this and start a new company and play this game and everything, you're going to be getting a nice little service present from your city attorney or your DA, or if you're really bad, the AG, Attorney General. All right? I just want to point something out. Lorena Gonzalez, who is one of the co-sponsors of this bill, of AB-5, she's out of San Diego. She sent a tweet just before the end of the year to all 4 city attorneys in her district, to whom she said, starting January 2nd, I want to see enforcement actions going. Okay? Could you imagine city attorneys who have no knowledge of business law trying to enforce this? Yeah. All right. So that's part of the improper consequences of this.